Hello and welcome everyone to another Sunday session with the legal legends, I would say. This season we have hosted the gods of justice, and again we are hoping and looking forward to active participation from everyone, and at the same time, our guests and faculties from across India who we will try to bring across to all of our participants, and we will obviously be hoping that we can get some good learnings out of this initiative. So once again, welcome to everyone who has joined in so far. Those who are watching it online, very warm welcome to you. Obviously, since we've started going live now on YouTube now, so please like, share, subscribe the channel. Leave your thoughts and comments in the comment box, but obviously we'll come to all of that. So for today's class, we have with us Shri Syed Naqvi sir. He's an advocate practicing in the Supreme Court and at various. To be honest, when I go through sir's resume, I can only understand that he has experience of going through all of the tribunals. So very briefly, just giving you an idea and an introduction to sir, he has an extensive CV, right? And this will probably take us time, but for today's reference, you can only come back to the bare facts of Sir's CV, which say that Syed Naqvi is a leading litigation lawyer. He has extensive experience of over 100 years in diverse and complex litigation matters across the country. He handles complex commercial disputes and civil litigation and has represented several large Indian and multinational companies in contentious matters across all business sectors. His litigation experience passes representing clients before various courts at all levels of Indian judiciary, including Supreme Court of India, various high courts and district court and civil courts across the country. So he has also practiced at Company Law Board, Customs and Excise Tribunal, Electricity Tribunal, Mines Tribunal, Water Disputes Tribunal, Monopolies and Restricted Trade Practices Commission, Consumer Courts, Boards of Industrial and Financial Reconstruction, AAIFI, Foreign Exchange Appellate Tribunal, Debt Recovery Tribunal, Press Council of India, Charity Commissioner Courts, Labor Courts, and Industrial Tribunals. So, besides the commercial and civil litigation, he also enjoys expertise in the areas of electricity, mining, and water laws. He has represented one of the largest electricity generation and distribution company of India for the Electricity Tribunal as well as the Supreme Court. He has over a decade of extensive experience and, in mining law, represented large mining companies before the mines at the High Court and Supreme Court level. He was the special counsel to the Narmada Control Authority and a consultant to the World Bank related to River Brahmaputra Development Project. He has worked with leading councils in India in extremely high stake cases and regularly receives their commendations for his cutting edge. So a more extensive will take us to a diary of 1,000 pages, which has over 10,000 that he has handled currently in his 34th year of practice. So, sir, I very warmly extend a welcome to you, and we're grateful to you for sharing your time. And I hand over the class to you, sir.
Right. Thank you very much, Keshav Sharma. Are we on? Yes.
Yes, absolutely, sir.
Right. Thank you very much, Keshav Sharma, for inviting me to this exciting online classes for young lawyers and young law students. And I compliment you for innovating this concept of pre-online legal classes. This is a very altruistic endeavor on your part. And once again, thank you very much for speaking for a few minutes. This subject that we have chosen to speak today is a combination of what is happening to our life as a lawyer today, as well as at the core of our legal practice, who we are. The subject, as you all know, is technology and the devolution of lawyers' acumen. So when we thought of this subject, I and Keshav had discussed that do we need to explain this subject so that there is no apprehension in the mind of the audience and the listeners here as to why have we used the word devolution of lawyers' acumen? Is it to run down the lawyers' legal life, legal expertise, legal acumen? But let me explain to you first what is this idea of choosing this subject. As you all are aware that technology has been a critical revolution in the evolution of the legal practice, and various facets of technology which has pervaded and invaded into our profession. So therefore, first, let us speak about how the technology has evolved and merged with our legal practice. I would take you to the time when our grandfathers, and not earlier than that, their practice of law involved using their handwriting and personal reading for the purposes of preparing the cases and going to the court. So not many years back, the legal practice was all about litigation and resolving legal disputes in the courts. So the concept of corporate law practice sitting in the chamber and the lawyers not going to the court evolved over a period of time when we in India brought in certain systemic changes to our economy, and that led to the growth of corporate law. But originally, the legal practice was all about resolving the legal disputes of your clients, going to the court and arguing. But before that, of course, how to prepare the cases. So therefore, they must have been before the introduction of what I would call the first tool of technology in the legal profession. I'm sure the petitions were handwritten and presented handwritten, processed handwritten, placed before the judges your handwritten plaint or petition and argued. But the first instrument of technology which came into our profession, according to me, is the typewriter which came into our life, that dispensed with lawyers having to write the petition by their hand. And typewriter helped us to type the petitions and file it in the court. They were acceptable. So you had various generations of typewriter, from the manual to the electronic. Now, with respect to the typewriter, yes, it helped us to expedite preparing the documents. So therefore, I will come to the first introduction of the typewriter into the legal profession, how it has fundamentally changed the manner in which we prepare the legal documents. According to me, this introduction and revolution of technology by typewriter into our legal profession is the starting point, according to me, of the revolution that technology has created in our lawyer's life. And then, of course, in the 1990s, when the computers became personal computers, because before the personal computers, you had large computers, and they were not the personal computer that you could carry or what you have in the offices. So the personal computers came in, and that helped us to prepare documents, prepare cases, not necessarily research cases at that time. So you had the introduction of computer and the printer somewhere in the 1990s, lawyers started using, and that definitely expedited the preparation of the legal documents. Transmission of the documents from one place to another place for lawyers, from the clients to the lawyers and the lawyers to the client, also helped us.
I request everyone to kindly put their mics on mute. We'll have a question answer session with sir at the end of the class. So please give me attention.
Are you fine?
Absolutely, sir.
Can I continue?
Absolutely, sir.
Right. So therefore, what you call the facsimile technology that was introduced in our profession helped us to transmit. Prior to that, we had physical mode of sending the document from one place to another place by the mode of, say, registered post or courier. Facsimile expedited the transmission of documents from the lawyers to the clients, to the clients to the lawyers. And then, of course, late 90s, with the introduction of the internet. This is the second generation, according to me, after the introduction of typewriter. Internet revolutionized the manner in which we look at the legal profession, how we use this technology. Then moving on fast, we had the next technology that we had was the email. Now, email also was a mode of transmission of legal document from one place to another, from clients to the lawyers, lawyers to the client. And then between WhatsApp and Google, I would take WhatsApp first, that who would have heard that a document could be compressed into a PDF and transmitted over mobile through PDF document from one place to another. So therefore, according to me, WhatsApp has revolutionized the manner in which the lawyers work. And then, of course, Google has brought in a tectonic change in the manner that we use computer. So therefore, over a period of time from the computer to the introduction of Google and the use of Google by lawyers, I think we have seen a huge revolution which is taking place, and Google brought in such a tectonic changes in the evolution of legal technology into the lawyer that we search everything on Google, we transmit our thoughts and our document through Google. Of course, the internet is based on the operating system that is Google. And then today, as we speak, we are seeing each other. We are able to communicate each other and do the webinar through YouTube. YouTube also was a great evolution in the concept of technology that in our profession. And then the next, I'm rushing fast because I want to tell you that how technology has changed the life of a lawyer. You all know this, but I'm repeating for the purposes of the punch that we have on the subject of devolution. So I would not like to come on the subject of devolution without explaining that how useful the evolution of technology and the absorption of technology into our legal profession has helped us. So today, as we speak, we are not doing a physical seminar, that good old days that we used to do, where you had a physical place, a conference room or a seminar room. People used to collect physically. Today, we have the concept of online seminar, which we call it webinar. This is what we are doing at this moment. I'm speaking to you through webinar. Now, this also is a revolutionary technology for interacting between the speaker and the audience. And more about webinar later. Then the technology use came into a very seminal change during pandemic, where the courts woke up to continuing the legal proceedings through virtual conference, which we call VC today. I would prefer to call it online hearing, but the use of virtual conference VC has gained so much popularity that most of the lawyers are using it every day to say, I was in VC for some time. And then during this pandemic, the technology was there, but the courts brought in another technological tool called e-filing. So sitting in the comfort of wherever we are able to file the petitions online, and then which is called e-filing. There is a technology available in the court. There's a technology available with us that we can file the documents online. And then recently, as early as the beginning of this year 2023, the Supreme Court and first the state of Gujarat High Court introduced live streaming of the proceedings. Now it's a very fast-paced technology into our legal profession, live stream of the proceeding. So therefore, people who wanted to know what is happening inside the court were prevented because they could not go to the court. And if you do not have your own case, you are prevented from entering the court. But you have now a Chief Justice of India sanctioning live streaming of the proceeding. So sitting anywhere, you can watch the proceedings of the court live. And then the last technological revolution, which is in the process of being integrated into our profession, is AI, artificial intelligence. Over a period of, according to me, the next 5 years, the artificial intelligence will completely complete the absorption of technology into the profession, where the systems, the technology system, may be able to prepare your legal cases on its own by your feeding the relevant facts and the relevant law into the system. So therefore, more on AI a little later. Now, to sum up this subject of technology, where do we stand today as far as the use of technology is concerned? Technology has helped us to expedite the process of interaction between us and the clients. Technology has helped us to store the legal documents. Technology has helped us to transmit the documents. Technology has helped us to search something which would otherwise have been not possible. Technology has helped us to interact between two people in the manner that was not possible. But technology has helped us to bring the courts into our drawing room. Technology has helped us to digitize the documents and be able to retrieve later. Is there any?
No, sir, please.
Is there any disruption? Can I continue?
Absolutely, sir. Please, you continue, sir.
No, so there was somebody speaking on it. So therefore, maybe when we do the next program on the same subject, more on technology, I would rather that if the audience is youngsters, young lawyers, and young students, that when you become a lawyer of 10, 15 years, by which time I expect that as we sit today to discuss the evolution of law, the discussion may become obsolete because the artificial intelligence will pervade our life in every sphere for that matter. But as far as the use of AI in our profession is concerned, according to me, that will bring in such changes which I think it is very difficult to even imagine as of today. So therefore, there was a discussion with respect to how long will that technology take time to automate the legal system, the legal profession, and the legal proceedings. Is it possible for the technology to pervade to an extent that there won't be any necessity for the legal professionals to go to the court and argue cases? You will just have to submit a formatted document, and the artificial intelligence technology will be able to tell you as to what should be the correct law laid down. Will artificial intelligence in a time to come, 10, 20, 30, 40, 50 years, this is my 34th year, so therefore in the 16 years it becomes 50 years. In the next 50 years, are we looking at technology which will revolutionize legal profession to an extent that the artificial intelligence will be used to determine as to what your case should be, and perhaps be able to give you a judgment based upon the artificial intelligence of the. So are we, that then my subject of the devolution starts from now, that are we leading by use of technology to a legal profession which will obviate our use, very use of lawyers and the courts and the judges? Because one fact remains that you cannot stop technology from keeping on revolutionizing. So you have got first generation computer, second generation computer, third generation. I don't know what generation we are in today, but I'm sure that it will be impossible for the human being, because we have set the ball rolling, that technology is becoming all pervasive. Today, almost every aspect of our lawyer's life is determined by the use of technology. are we leading to a stage of the use of technology where we as lawyers might become obsolete because the clients that we wait to service them may use artificial technology which may dispense the requirement of legal professionals. And I don't know, I really fear that even the judges who are today using their human mind and of course speaking through technology, live streaming or virtual hearing, that this march of technology. Now, why I give this caveat, the caution for the use of technology, because I see that if we allow this march of technology into our legal profession, we must seriously ponder that the tenability of our profession in the time to come. So therefore, we were very happy when we were substituting our physical preparation of the documents. As I take you to my first subject of introduction of technology, which is a typewriter, we were very happy to use the typewriter. Maybe 50 years from 50 years back, we were very happy to substitute the physical writers of the document, deed petition with a typewriter, which expedited the preparation of the document. Perhaps we had no idea that the introduction of this humble typewriter, which also required you to physically feed, physically roll the paper, physically take out the paper and read. But perhaps as of today, going back to the use of typewriter, we had no idea how in the last maybe 50 years, the introduction of that typewriter, which is a humble introduction of technology into our profession, has led to today a system of technology which is determining every aspect of our legal profession. And then if we end with, as we today see, that there is a use of artificial intelligence, there is a use of fuzzy logic. Fuzzy logic was introduced into the machine. But if the artificial intelligence, which is based upon a technology of its own, so we have today a chat GTP, which can answer any question. And just maybe few days back, I came across a WhatsApp forward that a lawyer asked chat GTP about a issue that he is facing with respect to the IBC law. And ChatGPT has been able to answer that question. Now, for me, it was not a happy reading because today the clients are asking the question, not to the legal question with respect to the IBC law, which is Insolvency and Bankruptcy Code 2016. They are not asking lawyer. They are asking ChatGPT, which is an application which is fast growing and becoming pervasive. So my point is made that technology use a time to come where we must pause, ponder, and perhaps be able to address ourselves that you must use technology to an extent that it does not substitute human mind and human brain. So here I go on to my next subject of technology and later devolution of lawyers' acumen. Now, the reason that I have merged these two diverse subject of technology and the use of devolution of lawyers' acumen is something related to what I spoke earlier about artificial intelligence. There was a time that legal profession required you to study law, to read documents, to read law, to read the cases, to be able to understand as to how best you can offer your legal services. So therefore, good old times, you read in India, the Supreme Court report, the Supreme Court cases, All India reports, and the other later on the judgments today, and they used to be an SEC. So those days, without the aid of technology, we read those judgments to be able to understand. Because when you read the judgment in physical form from one page to the last page of the judgment, there are many aspects of the judgment that you will be able to absorb as to how the judge is now representing in the form of a judgment the facts of the case, the facts pleaded by one side of the dispute parties, the other side of the dispute, what are the opposite contentions, what is the law applicable. So at the end of reading the judgment, without you realizing, you are developing the faculties of your brain in the manner that help you to retain. So therefore, that good old system of sitting down on the table and reading physically, in the physical form, in my view, was the correct way of developing the faculties of your human mind and brain. I will give you an anecdote at this point of time that maybe sometime in 1991, in one of the Northeast states, a person was recommended to become the High Court judge, maybe of state of High Court of Guwahati. Now that person had also performed some judicial functions, but he was not a judicial officer, which qualified him to become an High Court judge. It so happened that it was reported that so-and-so person, his name was, I think, Kesri Nanda Srivastava. He was about to be given oath after the government had recommended his appointment as a judge. We came to know at the Supreme Court, we filed a transfer petition, and at that time, the point of discussion before we went to the court was that what do we propose to the court? Is such a system of appointment of judges by the executive the right way, where you will have executive appointing judges of the High Court in the manner perhaps which is violative of the Constitution of Article 124 and other articles. So therefore, we proposed to the court that there is a precedent that we have of a Supreme Court wherein S.P. Gupta, Honorable Justice Bhagwati, as he then was, he is the one, as I don't know whether I'm introducing this knowledge for the first time, but the concept of collegium, as has become very debated today, was conceptualized and introduced in the Supreme Court by Justice Bhagwati judgment. If you read para 30 of S.P. Gupta versus Union of India, he proposed the collegium system. So we went to the court to say that there must be a system by which the judges of the High Court and higher judiciary appointed, there must be constitutional parameters, and the appointment process must not be left in the hands of the executive. Now, for citing this judgment of S.P. Gupta, we had with us a lawyer, senior lawyer from Guwahati. His name was Mr. Prashant Goswami. His father was the judge of the Supreme Court. Now, Prashant Goswami was a legal encyclopedia, a lawyer's encyclopedia. He has such a power of retention that when I asked him that I want to prepare a note for the presentation to the court by our senior Mr. Diwan on this collegium, I didn't have to look out for where this, he knew the citation of the Supreme Court report, he knew the page number of the Supreme Court, he knew the paragraph 30 of the judgment of Justice Bhagwati. And I remember, because if you see the physical judgment, the way it is reported, you have the page number, and on either side of the page, you have A, B, C, D, which is called placitum. He knew the placitum. Now, why he was able to remember the citation of this judgment, S.P. Gupta versus Union of India, who had written their judgment, and where is that word collegium introduced, at which page, which para, which placitum? Because according to my belief, he used to read the judgment in physical form and remember. And now, over a period of time, the manner in which we lawyers are studying the judgment is not on the physical. On my right-hand side, if you see the books, we used to pull out the books. We used to look at the index of the book to go to that particular subject, find out where our proposition of law is. But today, that has been largely overtaken by the introduction of computer application software, where we just Google that word and that word comes. We read only that paragraph, but we don't read the entire judgment. Now, over a period of time that we are compelled to use technology, in my view, the use of technology over a period of time has bifurcated the lawyers into good old lawyers. And I will give you another anecdote. There used to be a phenomenal lawyer in India called A.K. Sen. Now, to his credit goes that he was the law minister of the first cabinet of Jawaharlal Nehru. He was also the law minister of Indira Gandhi. He was also the law minister of Rajiv Gandhi. Now, such a stalwart of a man, he used to live just behind the present residence of Indian Prime Minister. He used to have a very, because as a member of parliament is entitled to practice. So he was a member of parliament for a very, very long time, including the ministership. And he used to have a huge library sitting on his chair in his office table in one of the rooms in his house. He could, in his thousands of books, he could point out to you which book is the relevant book for you to pull out for the purposes of the conference that we should. Such phenomenal memory. So my belief is that excessive use of technology into our practice of law is leading to the devolution of the lawyer's acumen. Now, law acumen is what we mean by our ability to understand, our ability to articulate. Now, if the physical form of absorption of the legal knowledge as compared to absorption of the legal knowledge through the use of technologies like Google, in my view, has led to a devolution of the lawyer's acumen. So we don't have now those great lawyers that we go to the Supreme Court from the time of 1950, the Daftaris, the Setalwads, the Dhiren Days, the Fali Nariman, the Soli Sorabji, the Andhyaru Jinas, the Anil Diwan. Now, the greatness of those people was that they used to help in the evolution of law. In my view, as I see the deterioration, the evolution of law that took place in our first 50 years of the courts, including the Supreme Court, was primarily because of these stalwarts whose absorption of the legal knowledge was based upon the conventional system, and they developed the legal acumen, which I am observing slowly is not evolving. We don't have the same crispness in our legal understanding because our absorption is through the technology. We don't have the patience to go through the entire judgment, the entire law interpretation. We are only looking at the particular proposition, but we are not reading fully a law or the judgment to understand and conceptualize the proposition. We are only picking up from there. So therefore, as we go into the 30 minutes of my presentation, this was meant to be a 45. So I will go back to the first concept, technology, that I definitely advocate the use of technology because it is inevitable. But please, simultaneously with the use of technology from that outdated typewriter to now we have a system by which we don't even have to use our finger on the Bluetooth technology keyboard. We just have to speak on our computer. The technology has reached a stage where when you speak, it types on its own in any language for that matter. It has expedited the use of preparation of the documents. But at the same time, my view for the, I won't say my opinion, but I feel that young lawyers and youngsters must be able to differentiate in their practice of law between use of technology should be only for the purposes of helping your legal mind, legal faculties in your brain to be able to absorb the law because law does not change with the use of technology. It is the manner of finding it. It is the manner of using it that changes. So therefore, the law, the judgments, the legislation, the books, they're all there for you. You are only using the technology for absorption, but the method of absorption, you must please go back to the conventional method of understanding the law, because that helps you to retain, that helps you to grow, that helps you to be an important member of the legal profession, because lawyers are a very important part of the society, important part of the legal system. You are called upon to help in the dispensation of justice, in the administration of justice, in maintaining law and order and public order in the society. So therefore, that's a minor role that you play. You must use the technology to an extent that it expedites your use of the legal resources, but do not substitute your faculty brain by making it one day a substituted artificial intelligence. Keshav, this is the part that I have spoken. I would like now for you to reflect, and then I will also propose as to how do I close it.
Absolutely, sir. It's really fantastic. I think the one thing which caught my attention the most was when you introduced the introduction of typewriter. So, sir, just out of curiosity, because I have never had the privilege, occasion, or opportunity of having any plaint or brief drafted on through a typewriter. So, how did it feel when, for the very first time, you saw that there is this machine which is in front of you, and people press buttons on it, and something is typed? I can't reflect on that, and I'm really inquisitive.
Right, that's a very interesting question. So, therefore, as I was a witness, I started my practice in 1989. So therefore, even in 1989, the manner in which the legal opinion the lawyers used to prepare or dictate of the petition, there used to be an agent between the lawyer and a typewriter, and he used to be called a stenographer. Now, a lawyer used to dictate to the stenographer, and the stenographer had a stenographical pad, and with the use of his pencil, I don't know why, but the pencils were used. So he used to take your dictation and translate that dictation into the typewriter. So therefore, you had a machine which, of course, by the time I saw how the lawyers use the typewriter through the stenographer, it had evolved to a very sophisticated machine. So therefore, you used to insert a paper on a roller. Now today, if you just dismantle the photocopier has more than 20 rollers inside. So therefore, the roller technology is still used. That is still the basic as far as the photocopying and the printing, because today the lawyers have graduated to using the photocopier as a printer as well. So today you can give a command from your computer to the photocopier, which doubles up as a printer. So the paper is picked up, it rolls over the rollers, it prints at one stage and brings it on the tray that you pick it up. Something like that. There used to be one single roller in the typewriter. You insert the paper, roll it, put it on a particular page, and then type out physically. And then if one typographical mistake was there, the typist used to retype it. But then the typing was faster than handwriting. So therefore, there used to be a typist who was also doubling as a stenographer. The stenographer used to take the dictation and they type it. So they used to be professional. Their unit of measurement of the expediency was better as how many words per minute. So somebody had 40 words per minute, somebody very good had 60 words per minute. So they were experts. So your employability as a stenographer depended upon how good you are a stenographer. Now, if you have to be a good stenographer, you have to be knowing how to understand the English language. So that breed of stenographer is slowly dying. I don't see stenographers in any lawyer's office anymore. There are very few stenographers who are still in the Supreme Court. They are either called court masters or bench officer. They are still taking, those are the typical stenographer, but they go back and feed into the computer. Now, this institution of the stenographer is very important. Now, he was such a educated person that he could understand the language of the lawyer in which he is dictating. He's translating that into a pad in shorthand. There used to be a language called shorthand, and the classical book on shorthand was by Pittman. So there used to be a book by Pittman. You learn how to learn the shorthand language. It's a language. Shorthand is a language. You won't be able to make out what it is unless you know the language. The stenographer used to go to his room and type. And if there is a mistake, there was no way that it could be erased. You have to retype it. The next generation technology was use of the so-called eraser ink called whiting. So the stenographer used to correct that and retype it by adjusting exactly on the same line. Sometimes he was successful, sometimes he's not. Then the typewriter, the second generation of typewriter was called electronic typewriter. So therefore, they had a memory. The typewriter used to absorb few lines and type it on its own. Then the erasing also was automated. So this is how the era of typewriter, which is now an obsolete. So therefore, in many offices you go, they display the typewriter as a adage of the old system of introduction of technology. But we have passed through that technology. As I told the audience, that typewriter, according to me, was the first technological revolution and absorption in the legal profession.
So that's actually a very fantastic thought to think about technology. Look at it today, because today obviously ChatGPT Supreme Court has also introduced the ESCR module, and frankly I love it. But I don't know. Sometimes I think that there are challenges with that also, and obviously I've seen with Supreme Court registry also so many challenges are there. They're also consistently trying to work on improving it, bettering it. So, but sir, considering that you started off with a typewriter, it has actually just made me think so much. I'm really curious to know one more thing. And for this, I would have to take you back to your initial years of law practice. That so when the typewriter was introduced, because obviously you would have had the opportunity of working with many seniors, and so you work with extremely, how do I say, well-renowned and very wonderful seniors in your past also. So before the typewriter, also when when we trace it all back, was there a point of time where how order sheets were written by hand? Were the plaints, petitions, everything written by hand and given? Like
that's a good question, because you take me to my grandfather days. He was the session judge in one of the cities of Uttar Pradesh, and we still have retained his handwritten orders. We still have his handwritten notes. We still have his handwritten books that he has written. So therefore, it is not necessary that typewriter was the one which was printing, because the printing machine was already there when typewriter was used by the lawyer, but on a larger scale. So therefore, there used to be a system by which the printing machine was there was a typeset. A typesetter used to prepare a page. There used to be the typeset A, B, C, D. So there used to be a row of metal called lead. The alphabets A, B, C, D was pre-prepared, and the typesetter used to prepare a page by typesetting, and then that used to be put on, if the plate used to be prepared, used to be put on the printing machine, and the ink was used, the paper was put, and then there was a impression of that plate on the paper, and you had to take out. So that has a system of rotation. So therefore, once a paper is set, then you could. So it is not necessary that before the typewriter, the judges only used to deliver judgment and it used to reach us by way of handwritten. It used to be sent for printing as well. But our subject today is the technology and how it has changed the life of a lawyer. So I have dispensed with the discussion of the use of printing machine in our system, because there was no requirement of a printing machine in our office. The typewriter was our printing machine. We dictate to the stenographer. The stenographer used to print on a typewriter. He used to give a couple of sheets of paper to us. We used to correct it and put it together in the format of a petition, and we used to file it. So therefore, But another thing that I want to digress a little and add to the concept of what I call the devolution of the lawyer's acumen. According to me, the lawyer's acumen also was that pre-Google, pre-computer age, and of course, the typewriter was no use for there was no connect between the brain and the typewriter, but there is a connect developed between the brain and the computer, because computer could think. It was made to think. So that was a starting point of taking over our thought process, part of our thinking by computer. So before the introduction of computers, maybe 1990s, when the computer came into the system, or the computer software came into the system, my life started with my senior, late Mr. Anil Diwan, in 1990, telling me, find out this proposition of law in the Supreme Court or High Court or any judgment for that matter. You take that proposition which you have noted down on your notebook, you go to the book shelf that a lawyer has. Not every lawyer may have a library like the Supreme Court or High Court, given the space constraint. And you have a set of books called Supreme Court Report, Supreme Court Cases, All India Report, Privy Council Report, or for All India, All England Reporters, what we call all ERs, or for taxation, we have Income Tax Report called ITR, or we had the Central Excise. Now, if a proposition of law for making it easy, was a constitutional point proposition. Now, the books does not tell you where to find it. So supposing I am in 1990, from 1950, the Supreme Court starts, and I have a 40 years of publication. I have no idea where that proposition is to be. And that is how the legal acumen developed. So what we used to do was, we used to pick up a Supreme Court report physical book. The beginning was contents and index, and at the end of it was a detailed index about what it contains. So supposing we are looking at a proposition on Article 14, the seminal law laid down by Justice S.R. Das in Honorable Sarkar versus Union of India, he explained, and which is valid today, what is all Article 14 about. So if you're looking at what is the position of Article 14 in 1990, when I was asked to do research on Article 14, you look at the subject index, Constitution, and under that you go to Article 14, and one or two judgments in that particular year may have been decided. You go to that page, you may find one judgment on Article 14, which has referred to Honorable Sarkar, the 1950 judgment. You read the entire judgment, and then you have 10 more years of the Supreme Court publication by 1990. You look up what you call noter up, the following. So that judgment of Honorable Sarkar would have been followed by next 50 years. In the 50 judgments, you read it, 50 judgments following Honorable Sarkar, refinement of Article 14, how he explained Article 14. You prepare a proposition on the piece of paper, you refine it before going to the senior, whether what you have prepared will be accepted by your senior or he will throw you out by an abuse. It was very common for senior lawyer to call a junior lawyer idiot. So we have grown up by being called idiot. We have reached today to speak before you, being branded as idiot by our seniors, because the difference between their understanding of the proposition and what you have prepared, there is to be a vast difference. This is what we have learned. And maybe 1 in 100 times, your senior said, this is what I wanted. And the judgment by your senior, that comment by your senior, yes, this is the proposition I was looking for, you, made your life, made your day, and made you what you are today. That legal acumen that we developed by thinking as to where that proposition of law could be, to help the court, to help your senior, to help your client, was that development of legal acumen, which my proposition is that the use of technology pervasively is devolving, reducing our ability to develop legal acumen. And therefore, I say that use of excessive technology in our legal profession is leading to the devolution of lawyers' acumen. Keshav.
Honestly, I have absolutely a lot of questions in this respect because how honestly, sir, it's really very fantastic that you when you first when we discussed the topic, I thought that probably we will want to speak about how exactly what exactly technology is doing today to influence the life of lawyers and litigants. But so one very important factor also which has come to my thought right now is the cost of litigation, which actually technology has substantially, I would say, affected because it's just the thought again that the moment when there was a typewriter, there was another person sitting typing, and that was very, very specifically, it's a niche field of practice to be learning how to typing also, and how you mentioned that the words per minute count and everything that would count, and how even the typewriters not everyone could afford, how a photocopy machine is today. So probably, let's say when copies have to be given to the other side, at least there would be today. So we take it for granted. We probably print one extra copy also. But at that point of time, what exactly would be the meticulousness required in ensuring that every single document that we have, every single page of every single copy that we have, how we should properly preserve it and how it should only effectively be given simultaneously.
Very good question. So I will take you to the last 34 years from typewriter to now e-filing. That typewriter, in view of e-filing, has become obsolete. Now, the revolution which started with typewriter, today we have reached a stage, because when you started the question about the cost factor. So today, you have a system by which you need to only prepare a document on your system, computer. You need not print it. If you are tech savvy, you edit your document by feeding. Maybe a large number of lawyers are preparing the petition by themselves without the aid of a stenographer. So take a situation where a lawyer is preparing a petition on his PC, on his laptop. He's editing on the laptop, and he is converting that document into the format of a PDF required by the court, uploading it. So what you have dispensed it completely is the typewriter and the use of the paper. The computer has become all pervasive in terms of you feeding into the computer system the petition or the document you have, and you're uploading. So therefore, obviously, it should have reduced the cost in the preparation of the document. Now, one important question to ask ourselves: who bears the litigation cost? It is the client. Now, I can tell you emphatically that the dispensing of the typewriter, the stenographer, the use of paper, and physically going to the court have had no impact upon the fees of the lawyer. The lawyer is not giving any discount to the use of the technology. So therefore, the clients, the consumers of the legal process, has not benefited from the technology, excepting that, as you say, that look, I am now using technology, so therefore I will charge you less. That has not happened.
So, but I very sincerely hope that this such initiatives as how you have humbly decided to come and contribute today, that in these manners technology will absolutely benefit people. May it may just help with their
and therefore I say that clients are more powerful than the most powerful lawyers. We should not forget this, because if we continue to charge the clients in the manner that we are doing without passing on the benefit of technology to them, a day may come where the artificial intelligence may perhaps enable the clients to prepare the petition on their own, dispensing the lawyer. Today, the online hearing, the e-court and the VC is dispensed. Many lawyers sitting in Delhi thinking that unless you come to lawyer in Delhi, you can't go to the Supreme Court. The VC has dispensed with the presence of lawyer in Delhi. In the same manner, in the next 25 years, the clients may say that we do not want lawyers to prepare our cases. We do not want lawyers to file the cases. Technology will enable them to prepare the petition on their own. There may be a printed format that the court will have to evolve. the client will just have to fill up that format and upload it, perhaps pay the fees on his own. The AOR system may also may be dispensed with because the initiation of the AOR system in the Supreme Court in 1950, they were called managing agents. So if you pull up any 1950 judgment, the name of the advocate on record was written managing agent. He was a managing agent, and of course the name changed to AOR. You need to write an examination to become an AOR. The AOR proficiency was he knew the court system. He knew which floor to go, which officer to meet. That has now been dispensed with e-filing. So therefore, I see that in a time to come and not very far from today, the technology may do away with the institution of AOR. In the same manner, after 25 years, the technology may dispense with the preparation of the petition by a lawyer, and we may be only called up by the court to say, on so-and-so day, you have a 5-minute hearing to explain particular, otherwise everything has been automated.
But I am also actually, I've given my intimation for AOR examination preparation. So I hope that, it continues for some time, and probably we'll also have, some guidance and some thought on how to probably tweak it. And
I will interject only that when I was working with Mr. Diwan, he used to subscribe to a journal from America called American Bar Association Journal. Even in 1990, a large part of the magazine was devoted to technology. And I read one article to say, if the lawyer today is not ready for what is going to happen to his profession 10 years from now, he is not ready for the 10th year. So you must be ready for what is going to happen in the 10 year. And I can tell you with the way the technology is moving, the introduction of artificial intelligence will dispense with many institutions. Forget about AOR. The Bar Council may have to sit to redetermine the role of lawyers.
So in this respect only, there are two questions by Miss Isha. So we'll take the other one. One is regarding research, other one is regarding the same topic that you've just spoken as of right now itself. So we'll take both of them, obviously, but first, in light of this current conversation itself. So she says, sir, will technology replace judges as well, or only lawyers in the future, in accordance with your perspective?
Right. So therefore, this will be a evolution. Evolution takes time. So therefore, as I said, everything evolves. So the first fear that I have of dispensing the role of lawyers will happen first, then the dispensing the judges to deliver judgment. So therefore, now, fortunately, there are some areas still where neither AI, or technology or AI, will be able to dispense with the power of the human mind. So therefore, I don't see elimination of lawyers and judges completely from the justice delivery system, administration of justice, because the society to which the legal system addresses has a way of coming out with the propositions of disputes all the time, that it will not be possible for the technology to be able to dispense the answers which only the creators created human mind. So I definitely see that a time may come where the AI will determine this proposition of law is no more res integra. It is already covered by 10 of the judgments. So the judge do not have to tell the client or the consumer of justice, a lawyer or the litigant, that this proposition of law that you brought is already covered. So I see that the length of the hearing in the courts will drastically reduce by the use of AI. So you may have a smaller vital role still remaining at the end of the world for both the lawyers and the judges.
So I think, sir, that is a very nice perspective. In this respect itself, I was reading somewhere, sir, that some judges only, I think, of the Honorable Supreme Court itself were quoting that there is some probably thought going on with respect to putting 138 matters check bounce, as well as all these traffic challans and also virtual courts they've already made. You can go there and you can online fill whatever challan you have. So probably, I don't know how and what they intend to do with it, but these are two thoughts that I have gotten to know, and it's relatively scary because these are some staple cases that keep coming, and obviously it's good that it's easier for all the litigants, and I'm quite sure, as you very rightfully said, that there will obviously be a lot of perspectives and challenges development where the human mind will obviously supersede any kind of technology, because at the end of the day it will still require some kind of direction and some the discretion. The word, I think, is in itself one word which keep.
Just see, for that matter, that let's see the development of technology. There was a time that you had no idea to find out where your case is listed. So you have to go through physical list. You have to go through each court to find out where your case is. It used to take us enormous amount of time. The list used to be physically printed by the Supreme Court registry. It used to be distributed to the doorstep of a lawyer late in the evening or the night. You used to have a clerk or a librarian or a junior going through the entire 200 pages of the list and mark out where your case. Today you have a chaos outside every court, in every high court, which is a computer attached to a kiosk. You just go there and feed in your query and you would know where your case is listed. Now, if you use this basic system of ascertaining where, in which court, at what item your case is listed, you don't have to see the 200 list or ask inside the registry of the court. If this can happen as of today, is it not possible that this kiosk will one day substitute the substitution of the judicial dispensation by saying that, look, if you have any legal query, feed in, you get an answer here. You don't have to go out to a lawyer or you don't have to go to the judge. I see this happening very soon.
Yeah, absolutely. So I can see that in that example which you cited also, wherein someone asked ChatGPT for some sort of a legal opinion. So I was also experimenting. So this is something which I would also want to share. So this was not ChatGPT. This was some other online AI drafting platform, and I wanted to see that what exactly are its capabilities. So I actually gave it a relatively complex legal proposition, and I kid you not, sir, it's a very simple thought that I know for sure that if I would have given that same question to probably any, even a third year law student for that matter of fact, obviously not someone who has, some experience in putting in, obviously I was studying with people who were 50, 60 years of age also when I was studying my law. So a very normal law student who has just finished the 12th and who've gotten into law and who are learning, practicing, even working hard, even for them, I know for sure that it would have relatively made them think. They would have had to do a lot of research. They would have had to probably have some prior experience in drafting also. I gave it, I even put in that, give me case laws, relevant case laws in that respect. You give me the proposition, you give me what exactly is it your thought. And sir, it gave me effectively a proper document of about 1,000 words with case laws, with its opinion, with both sides of the story. And that's it actually made me wonder for a second that where exactly are we headed. And again, I'm also very curious in this respect. And the ESCR initiative, which I think the Supreme Court has done,
I understand.
It's
right.
It feels very promising to me how at least no matter what they've made accessing judgment very accessible. So in this respect,
so I will tell you something to keep the interest intact on the technology. See, what is technology is the use of law. When the 90s computer, the search engine, the parameters were you need to type the exact word to be able to search. Thereafter, a language was developed called Boolean language, Boolean. The Boolean was able to answer your question by straightforward question. What is this? So today, from that 1990s Boolean search engine, what has developed is that the search engine of the computer has become extremely powerful, that it can search anything among billions of pages to be able to give you that information. Now, the problem is that our search engine and our brain is far more powerful than this search engine of the computer. The only problem is that the computer is able to use that search engine more effectively than the search engine that our brain has. We must learn to use the search engine of our brain more powerfully than what we're using today. And I'm sure we will be able to beat the search engine of the technology.
Absolutely, sir. I second your conviction in this aspect. So also I'll
Thank
want
you.
to ask everyone that, since I am only hogging all the questions, and I don't mind that also, everyone knows that, I think everyone knows. So, but, if there are anything that anyone wants to ask, or, anyone
They can
wants
write to me. They can write to me.
yeah, and even right now also, so we try to have this, sort of an experience wherein people can ask questions, they can, whatever it is that, it's a very
My pleasure.
convenient time to interact also with you.
My pleasure. I believe that every lawyer must pass on his legal knowledge, share his experience and expertise. Otherwise, keeping it locked up in our brain is not going to help our profession. We must come back, and I congratulate you for doing this session of the online free classes. So the combination of an online classes and that too free, it's very altruistic. And I congratulate you for that, and all the best from my side. And thank you very much, everybody who has joined to listen to me.
Absolutely, sir. And it's only possible because of your blessings also, that you have chosen to give your valuable time to us on a Sunday. So, but again, sir, there are certain thoughts. So, Mr. Badruz Zaman Chaudhary has a question. Would you want to ask your question? Please go ahead.
Good afternoon, sir. Sir, it's like it's not a question as such. Sir, if I want to write to you sometimes in future, sir, would you please share your email ID, sir?
Your voice is not clear. So, Keshav, you can repeat his question.
Yeah. So actually, sir, he is asking for your email ID to be able to approach you. Because what we can do is, if you are a part of our WhatsApp group, so you can, because again, this video will also be shared on YouTube. So I don't, sir, if I don't want to necessarily, if you want to share it over here also, that's also fine. And I think that's also.
Please share. Please do share.
Yeah. So, Badruz, you can just send in a message. You can. I hope you're there in the WhatsApp group.
Yes.
Yeah, so we'll share Sir's detailed brief bio. I'll also share the LinkedIn profile. Okay. Because again, there's a very interesting thing about Sir, that he has more than 10,000 cases that he has handled. So a lot of perspectives of water disputes and all. Also, you have seen, and these are the kind of things that we really want to be able to converse on and come across to people. How we spoke about technology today. Probably, hopefully, in the future also we'll have opportunity to speak about this thing. Because these are very unique propositions on law. Again, it's the simpler from what I understand, so the simpler the aspect of law, such as how the 138 cases or the traffic challan cases today, they are straight away putting it to automation. So the more complex it is, the more likely it is going to survive as a professional, fee earner, or howsoever one may choose to probably put it. But at least it stimulates the mind. So
thank you.
Great, sir, to have all of these conversations. Anything else that anyone probably wants to ask or add to this conversation?
That's all for now.
Yeah, I think that's so. So I'll reserve my questions for you later, which I will. I know for sure I'll have the humble opportunity of meeting you in person. So and apart from that, we'll discuss all of these things hopefully in the near future also with you, sir. And I very sincerely and very humbly want to thank you for taking your time out today on a Sunday morning and giving us this time, sharing with us your wonderful and very innovative thoughts. For stimulating my mind, sir, honestly, because that thing of the introduction of typewriter, that particular state, I know that the introduction of AI in the legal field would most definitely amount to something very similarly radical and disruptive. And let's see how and where it goes. But I'm sure that with the blessings of all of our seniors who are present, all the seniors who keep taking time to contribute, teaching us, helping us learn and grow, that it's only going to be better.
Thank
So,
you.
very humbly,
Thank
sir,
you.
thank you so much. I thank every single person who has participated in this
Yes.
session today. Anyone who's watching it online, thank you so much. If you've stayed so far, then please like, share, subscribe, and let's keep the conversation going. And with that, sir, I request your
Thank you.
permission. Kindly.
Thank you very much.
Thank you so much, sir. Thank you so much. Thank you, everyone. And I hope that everyone had something very interesting to take away from this class. See you.